go around. Are we ready on Mr. Oliver De La Rosa,
Yes.
22M705? Defendants present with the assistance of Ms. Moya. I have Ms.
Catherine Victor on behalf of the
Okay,
people.
all right, so something, all right. Ms. Victor is present. We're set today for a hearing on revocation of probation. The court has reviewed the complaint. The court has reviewed the motion to revoke the deferred sentence as well. But we're going to hearing today, right?
That's correct, Your Honor.
All right, you can call your witness.
Your Honor, before the people's first witness, I first asked the court to take judicial notice of the court record pursuant to People v. Linares Guzman, that a court can take judicial notice of its own records. And I just further asked the court to take judicial notice of defendant's original sentence to a 12-month deferred judgment issued on February 18th, 2022, where he was ordered to complete a domestic violence evaluation and treatment, and then comply with monitored sobriety.
Your Honor, I object to that characterization of the document. Nothing in the deferred judgment agreement indicates that he must comply with monitored sobriety. That was a condition imposed by probation. So I don't think they can take judicial notice of something that does not exist.
Probation terms and conditions are still the court order.
But the court order is to comply with the terms and conditions of probation, not to comply with monitored sobriety. I just want that to be clear.
Okay.
I would further ask the court to take judicial notice of the probation supervision extension granted on February 3rd, 2023 for another 9 months on November 1st, 2023. And then lastly, I'd ask the court to take judicial notice of the motion to revoke the deferred sentence filed by the people on January 24th, 2024, alleging that the defendant failed to submit 22 UAs, or submitted 5 positive UAs, and then would amend that complaint to include the most recent positive UA for cocaine as well.
All right, so there's filed back-to-back 24th and 25th.
They're the same document. I think there was a filing error.
Okay. All right.
Your
Okay.
Honor, with respect to the latest UA, I'm aware of it, but I don't see any documentation in the court file regarding the latest UA. Has that been served upon the?
So I'm now asking to amend the complaint to include that 6th positive UA.
Based
The
on what?
reason why there's no filing, the people received confirmation of the positive UA this morning, which will be submitted for the court's review. I only have 1 copy, but I can let Ms. Moya review it as well.
I'm just asking, I would ask that Ms. Victor relay a proper foundation and admit that during testimony. I don't think that the court can take judicial notice of something that is not in the court file.
I'm asking to amend the complaint. That's all. That's why we're here for hearing.
All right, why are we here? Why are we doing this?
Your Honor, I can cite the basis for which I'm here. I'm directing the court's attention to 18-1.3-102. And particularly, I'm looking at subsection 2 of the statute. This, I'm looking at about halfway through the paragraph that begins with the sentence, the stipulation, wherein it is indicated that the stipulation shall, for a deferred judgment, shall specifically provide that upon a breach by the defendant of any condition regulating the conduct of the defendant, the court.
Slow down.
Yeah, sorry.
Thank you.
The court shall enter judgment and impose sentence upon the guilty plea, except that if the offense is a violation of Article 18 of this Title 18, the court may accept an admission or find a violation of the stipulation without entering judgment and imposing sentence if the court first makes findings of fact on the record stating that the entry of judgment and sentencing would not be consistent with the purposes of sentencing, that the defendant would be better served by continuing the deferred judgment period, and that public safety would not be jeopardized by the continuation of the deferred judgment. So the reason we're at this hearing is to establish those facts for the court. I've been negotiating this case with Ms. Victor for some time, asking for dismissal of the complaint. The only non-compliance at this stage of Mr. Oliver De La Rosa's failure to comply are these missed and positive UAs.
And so let me get this straight. Despite the positive UAs for cocaine, which is an illegal and illicit drug, you're still thinking that he should still be on a deferred judgment.
I'm asking that the court make a factual finding given the totality of the circumstances, to not enter the conviction against Mr. Oliver De La Rosa, which the court does have discretion to do.
Yeah, but you got a tough battle because right now, if he's going to continue to test positive for an illicit drug that he can be charged for separately, and the only thing that he's facing is this revocation, he should probably accept the revocation and move on with his life. But I'm happy to take testimony, but this is going to be a tough road to hold because no one can convince me otherwise that using cocaine while on probation is a basis to keep your deferred judgment. If anything, he should lose his deferred judgment, conviction should enter, and we may be able to close out probation possibly, but you got a tough road to hold ahead of you. I'm not saying that you
This is
can't.
supposed to be a hearing. The court can't make up its mind before hearing any evidence.
I'm not making up my mind, but if you, unless somebody's.
Literally just did, Your Honor. You said you were not going to take any factual evidence.
Did you hear me say that?
You said that it would, that you cannot see a way in which with the positive tests that you would be able to find these factual findings, I guess, as outlined in the statute. You didn't
not
think
what
that
I
there
said.
was a way.
That's not what I said.
You have a very hard battle, Your Honor.
You got a tough road to hold.
And then what you said is you had to be convinced otherwise.
Yes, you're gonna need to convince me.
So there's.
So when I say that you need to convince me, that means we're gonna have a hearing. That's not me making up my mind. Now, I understand that's how you are reacting overly emotionally on this aspect, and I get it. However, I didn't say that you're not entitled to a hearing. We're gonna hear the hearing, but unless you can prove to me while a person who's alleged to have used cocaine and tested positive for an illicit drug that's on a scheduled event, why a person who continues to use should be allowed to maintain a deferred judgment, you're gonna have a tough road to hold, but I'm willing to hear it. You didn't hear me say, I am not going to take testimony or I'm not going to have the hearing. You didn't hear me say that at all. But I want to give you all a heads up. This is tough because a person who continually violates the law and then being asked to just for me to ignore the violation of the law, that's a problem. So I am going to take judicial notice of the fact that he was sentenced on February 23rd, 2022 for consent of entry or deferred sentencing. I'm taking judicial notice of the plea agreement. I do note that he was to do an evaluation for domestic violence evaluation and treatment as recommended. The court also takes notice of whatever the agreements was that the probation department indicated that he signed off and agreed to. Of course, going to take judicial notice of the motion to extend the probation that was filed on February 2nd, 2023, and then granted on February 3rd, 2023. The court will note that under the request for an extension, he was sentenced to 12 months. The term of probation was that he do the domestic violence classes. It says comply with the monitored sobriety program and also order to pay the cost. As of the writing, the defendant has completed his domestic violence evaluation, which is great. 16 domestic violence level C therapy sessions and 17 helping men recover treatment sessions. And he's also paid his court costs and fines in full. It looks like the only issue is him continuing to use illicit drugs. So the court takes judicial notice of the motion to extend. As it relates to the newest finding and the usage, the court will allow testimony on that particular issue at this stage to determine whether or not the evidence is credible, and we'll go from that route. You can call your first witness.
People called Tito Garcia of intervention.
So please raise your right hand. Do you swear or affirm under penalty of perjury to tell the truth? Great. If you could please grab a seat, state your full name for the record.
My full name's Tita Nay Garcia,
Spell your last name for me.
Garcia.
All right, I'll turn it over to the people.
Thank you, Your Honor. Ms. Garcia, could you explain your occupation and a general outline of your duties in that occupation?
I am a case manager for intervention, which is a nonprofit, private probation service, for different counties, in Colorado.
So essentially, are you a private probation officer?
Yes.
And what training and experience did you go through to become a private probation officer?
In order to have, to be a case manager, you have to have your 4-year degree. And training is like assessments, so like the LSI and stuff for our clients. and also like managing caseload of different cases.
And in your course of employment as an intervention case manager, did you work with Alfredo Oliver de la Rosa?
Yes, I did.
And for approximately how long?
For a little over a year.
And were you always, or the only assigned intervention officer from the start of the case?
No, I was his second.
And is that typical?
Yes. Mm-hmm.
And what communication, if any, do you get from the previous case manager about the case?
The only communication that I had was like her crons, whatever she had in her notes of the file. I was not trained by her.
Okay, but are you familiar with what happened before you were assigned to the case?
Yes,
And do you see Mr. Oliver De La Rosa in the room today?
yes.
Can you identify him by an article of his clothing?
He's wearing a black hoodie.
Your Honor, let the record reflect that Ms. Garcia has identified the defendant subject to cross-examination.
Still subject to cross-examination.
To your knowledge, when was Mr. Oliver De La Rosa first placed on probation?
He was granted, his deferred judgment in February of 2022.
And for how long was he to be on probation?
12 months.
And did he sign the terms and conditions of his probation?
Yes,
And was he advised on what those terms and conditions were?
yes.
Your Honor, may I approach the witness?
You may.
Your Honor, I'll note that for the record that this exhibit is in Spanish. I do speak Spanish, but I do think that there's some prejudice here. This was not a document that was provided in discovery on this case. If I weren't a bilingual attorney, defense would not have had any opportunity to review this matter, and there's no comparable English copy of this. So based on the discovery violation, I'm asking that the court not allow the admission of this document.
What is the document?
Well, Your Honor, it's the probation terms and conditions that the defendant signed. I will also note for the court that I received that document this morning, and I also do not have an English version, and it is a court record.
All
Is it
right.
in the court file?
Well, the signed terms and conditions are generally not in the court file.
So it's not a court record, Your Honor.
So it is a business record. It meets an exception. It's a document that he signed. Let me hear additional argument or additional foundation. This goes to weight, not to admissibility necessarily. So I'm likely going to allow the document in. Did he sign it? Does it?
Your Honor, I'm not sure.
Then let her finish making the record then.
But
Make
Your
the
Honor, I'm
foundation.
arguing that we're prejudiced in this hearing because it's the first time I'm seeing this document. It's not in discovery. I was not adequately prepared for this hearing because I'm getting this document for the first time.
Would you like a continuance of the hearing? So I'll give you a continuance.
Let me speak with my client.
Your Honor, if I may supplement the record, I think it's just disingenuous to say that this document is prejudicial. This is a standard operating procedure that happens on every probation case where the client reviews the terms and conditions and signs off on them before agreeing to start
The
probation.
document itself isn't prejudicial. It's the fact that I did not have access to the document until the middle of the hearing.
So if you want a hearing, if you want a continuance, I'll grant you the continuance.
I just want to talk to my client first. Your Honor, we are asking for continuance at this stage.
All right, people, I understand you probably objecting. You just got the file. Here's my recommendation to both parties, so we don't have this issue again. If there's anything within your file, within their file that they have, get copies of it, provide it to the people or the defense, please, so that they can have it. That way, when we come back here, parties will have an opportunity to discuss the documents. You all know my policy. I prefer that you all have conversations, express any disagreements that you may have about documents so that we can address it. I don't want there to be any surprise or anything in that respect. I just want parties to be on the same page and on the same level playing field. So I'm going to grant the continuance. People, you can make your objection if you like to, if you have one.
I will object for the record and just continue the record that I don't believe these documents are prejudicial. The bar here is by a preponderance of the evidence. I don't think any of these documents or evidence is unanticipated, but I do understand defense's objection.
I don't necessarily disagree with you with respect to the documents. However, I'm always of a person, I prefer that the parties have full access to all documents that are going to be presented. If she's just now being presented with this, I'd be happy to give her time to review it, but we have an interpreter who has some time and I have an officer who's sitting back there, so I'd rather just move forward on others. So I'm going to give you that continuance. Take the time you need.
Thank you, Your Honor. If I get a copy in English, I mean, I can read this, but I would also like a copy in English if possible.
Well, the question is do they have a copy in English? Due
If
to
these
the
are
fact that
standard
the-
terms and conditions, I mean.
This is the document that was provided to me. It is clear by the presence of the interpreter that Mr. Oliver De La Rosa only speaks Spanish. I don't think it's outside the scope of reasonability that the document that was provided and signed would only be in Spanish.
I guess the concern is that what's going to happen when it's admitted? Are we going to be translating this entire document for the court? So if the court file is aware of what the document says in English, I think it makes sense for all parties to have access to the copy of the document in English.
I'll let y'all figure that out. If y'all can reach an understanding and agreement on it, the court will be fine either way. Let's get a court date. We're not gonna go very far. We're gonna do this before I take my vacation, which is June 13th. So we need to find a date.
June 10th.
Ms. Garcia.
Sorry.
No, go, stand up, take your time.
You know, if you have any conflicts in the coming weeks where you could not appear for a new hearing?
No, I didn't.
June 10th, what time works best for you? I don't want you sitting here all day. I'm willing to go later in the day or.
Your Honor, I would prefer if we could do an afternoon setting if the court can accommodate that, or if we can push this later in the morning. Ms. Garcia did arrive here before 9:30.
Yeah, I agree, Your Honor. I would like something either later in the afternoon, but
Can you do one?
like morning.
We can do July or June 10th at 1:30. What's that hearing? Who's the attorney? We have a Crespin matter set at 1:30. I don't know if that's.
Crespin, I think this is Churchill's case. I believe it's resolving. Oh, that's Cyprian. I'm sorry. I don't know who this is.
So let's set this at 2 p.m. Is that okay with you? Oh, no, that case is going to be placed on, remember, that's the case we did in felony week. That's going to be placed on the magistrate's docket. One of the magistrates are doing it, so that should be.
So can we do 1:30?
1:30. 1:30 at that time. Thank you very much for your time. Thank you for your patience as well. All right, we'll be in recess on that matter.
I just want to.
Colleen, it's always a pleasure to have you in the courtroom. I just need you to know that.
This is just some lower ups and frowns.
All right. I would do that. I was sure. Yeah.